Distinction between tort and contract. Breach of contract. Introduction of contract. A written or spoken agreement, especially one concerning employment, sales, or tenancy, that is intended to be enforceable by law. Definition of contract. A contract is an agreement that is enforceable by a court of law. A contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. How the tort is distinguished from contract. The distinction between tort and contract was recognized and stated in its present form only on comparatively modern time. Till 16th century the form of action for a breach of a simple contract was not provided, but its purpose was served by an action of trespass on the case. The growth of trade and commerce which resulted in the increase of litigation in contracts made a special form of action of assumpsit, by converting the old action of trespass on the case. In 17th century this action had become very popular. At this stage the distinction between tort and contract emerged. When the forms of actions disappeared in the last century, greater attention to judicial principles and distinctions became possible, and the difference between a tort and a breach of contract was stated in the form of distinction in the nature of the rights or duties. Prof. Winfield, at the present day, tort and contract are distinguished from one another in that the duties in the former are primarily fixed by law, while in the latter they are fixed by persons themselves. Moreover, in tort the duty is towards persons generally, in contract it is towards specific persons or a specific person. Distinction between tort and crime. The following are the distinction between tort and contract. Duty. In tort the duty is fixed by the law itself, while in contract the duty is fixed by the parties themselves. Example, A owes a duty to deliver 20 bags of sugar to B can only be discovered from the contract between A and B. Nature of right infringed. A tort is a violation of a right in rem, example, of a right vested in some determinate person and available against the world at large, while a breach of contract is an infringement of a right in personam, example, of a right available against some determinate person or party. Consent. A tort is committed against or without consent, while a contract is based on the consent of the parties. Example, A is under a duty not to assault B, not to slander him, not to trespass on his land, because he has made an agreement with B to undertake such duties. Damages. In tort measure of damages is different in different circumstances, which may be nominal or exemplary, while in breach of contract damages are awarded in the form of compensation for pecuniary loss suffered. Third-party relation. A third party can sue for tort even though there was no contract between the person causing injury and the person injured, while a third party to a contract cannot sue for the breach of contract except in some exceptional cases. Privity. In an action for tort, no privity needed or is required to be proved, while in a breach of contract privity between the parties must be proved. Motive. In tort motive is often taken into account, while in breach of contract motive is not relevant. Application. In tort the duty is towards every person of the community or society, while in contract the duty is towards specific person or persons. Core purpose. The core purpose of contract is to enforce promises, while the main purpose of tort is prevention of harm or its compensation. Functions. The difference in function, according to Winfield, has two principal consequences. 1. A mere failure to act is not actionable in tort. 2. Damages cannot be claimed in tort for a loss of expectation, which is the case in contract where the claimant is put in a position he would have been had the contract been performed. Concurrence between contracts and torts. There are two situations where contractual and tortious duties may exist on the same facts. Duty owed to a third person other than the one with whom contract is made. Donahue v. Stevenson. This case is the basis of the manufacturer's common law liability in tort to the ultimate consumer. The proposition that the defendant may incur liability in tort, in particular the tort of negligence, to the plaintiff from a matter or transaction in respect of which defendant had a contract with a third person. 2. Duty to the same person with whom the contract is made. Henderson v. Merit Syndicates Limited, 1995. the House of Lords says, the result may be untidy, but, given that the tortious duty is imposed by the general law, and the contractual duty is attributable to the will of the parties, I do not find it objectionable that the claimant may be entitled to take advantage of the remedy which is more advantageous to him. E.g., other cases are client and lawyer, doctor and patient, etc. It is a breach of contract because the physician has impliedly promised to use due care and skill in the treatment of his patient, and it is also a tort because, apart from contract altogether, no one has a right to do another physical harm by giving him poison. Duty of care: when the relationship does not give rise to any duty of care to plaintiff, no action in tort can be maintained. So where a message is delivered by a telegraph company in error to a person for whom the message was not intended, and who in consequence suffers damages, no action will lie, for there is no privity of contract between the parties, nor is any duty of care cast upon the telegraph company independent of contract. Person for whom the message was not intended and who in consequence suffers damages, no action will lie, for there is no privity of contract between the parties, nor is any duty of care cast upon the telegraph company independent of contract. Quasi-contract. A person is held liable for the benefit received by him to which other person is entitled. Example: if a person has received undue advantage to which he is not entitled, it is then his duty to return such benefit to the person who is entitled. Distinction between the tort and quasi-contract. Remedies: quasi-contract gives right only in respect of money, whereas tort gives right to damages as well as grants other remedies also. Claims: claim under quasi-contract is for liquidated sum of money, whereas claim under tort is always for unliquidated damages. Right against persons: rights arising out of quasi-contract is against particular person or persons, but under the law of torts duty is towards persons generally and not to a definite person. Primary duty: the duty under torts arises because of breach of primary duty, but there is no primary duty whatsoever under quasi-contract.